Good afternoon, everybody. Thank you for attending How Individuals with Brain Injury May Benefit from Legal Advocacy and the Guidelines for Self-Advocacy. Before we get started, I want to remind everybody about CEUs. You will be receiving an email with links to evaluations for the workshops you attended, and completion of these evaluations is a requirement for earning the CEUs. And also, you may visit BIANJ.org, our website, to view poster presentations that were presented by senior level students in healthcare. So the workshop for today is being presented by staff from Disability Rights of New Jersey. I'm sorry, Disability Rights New Jersey. Gwen Orlowski, Executive Director. Michael Brower, Staff Attorney, Protection and Advocacy for Individual Rights Coordinator. Mary Chacon, thank you, Director of Policy, Coordinator for both Client Assistance Program and Protection and Advocacy for Voter Access. And then Susan Head, Staff Advocate and Coordinator, Protection and Advocacy for Individuals with Traumatic Brain Injury. Gwen and Michael will lead a conversation or discussion on accessing home and community-based services and guide us through a Medicaid TBI-specific home and community-based services appeal. Mary will discuss the scope of employment supports and services available to individuals with brain injury. Susan will facilitate an interactive case study discussion with our panel and you. If you do have any questions, enter them in the Q&A tab. They will be addressed during the Q&A session in the latter part of the workshop, and the workshop does end sharply at 1:20. Now, as part of this workshop, I am to give a brief summary of legislative matters that are going on in the state of New Jersey with regard to COVID-19 that has taken up a lot of legislative time, a lot of legislative effort. So there really isn't too much information to present on that regard. However, the Brain Injury Alliance of New Jersey does have a legislative portfolio for state legislation, as well as a congressional portfolio for congressional legislation. If anybody's interested in receiving those, you can reach out to me after the presentation. I'll be happy to share those with you. The email address is tgrady@bianj.org. I'll repeat that again. It's tgrady@bianj.org. In terms of some particular efforts we're working on, we're looking to create an acquired brain injury fund, and that would be modeled after the traumatic brain injury fund that would serve people with traumatic brain injury. There is a need as a payer of last resort for some people with acquired brain injury, meaning those who sustain brain injury through stroke, AVM, tumors, things of that nature. So these people are no different than those who have a traumatic brain injury, ones that are sustained through a crash, a fall, etc. But their needs are, in many cases, very similar. So we're working on a potential proposal to submit to the legislature for their consideration and hopefully to Governor Murphy for his approval. Now, given the status of COVID-19 and many government resources are being applied toward that effort, we are not meeting with the governor's office quite yet, but we are in the process of collecting petitions that basically say, hey, we think this is a good idea. Governor and legislature, please support it. So if you're interested in helping us out in terms of getting petitions or advocating for this particular cause, please email me again at tgrady@bianj.org. Some other efforts we're working on or will be working on very soon are a result of other pieces of legislation that have become law in the past couple of years. One is Brain Aneurysm Awareness Month, which is happening in September of each year. The other is Concussion Awareness Day, which occurs on the third Friday in September of each year. So where we are with that is we are requesting proclamations, or have requested proclamations from the governor's office, asking him to create these proclamations so that we can go out and raise awareness of both Concussion Awareness Day and Brain Aneurysm Awareness Month in hopes of people getting involved and simply making the whole public aware of those two brain injury related topics. One issue of particular concern to the Brain Injury Alliance is funding for community-based services. This is a budgetary issue. It is a relatively small appropriation of $140,000, but that money is needed to fund various alliance services, such as it funds part of the annual seminar, which we're part of now. And luckily, the governor had that funding in his proposed budget for 2021 it will be, which begins January 1st or July 1st, excuse me. He did have that in his proposed budget. However, there is word that he may submit a changed budget to address the COVID-19 issue. So we have to be very vigilant in making sure that that $140,000 does stay in the governor's proposed budget, whether it's the one he uses now or whether it's the one he would create in the future. Some other more housekeeping items that we are involved with. The Alliance, as you can probably imagine by now, does a lot of coalition work. And we're willing to and eager to partner with organizations such as BIANJ to address issues of mutual concern pertaining to brain injury. And then we also play a supportive role in our advocacy and public affairs efforts. We assess legislation, we monitor legislation, we get ideas of issues to address from our advocacy group called the Council for the Head Injury Community. So there's a lot of room to, I think, partner with a broad array of organizations with various brain injury issues. One other thing I would suggest is if you want to stay connected to our legislative and advocacy efforts, you can also submit to me your name and ideally the town in which you live. There's no need to submit your particular address. The reason I suggest your town is because that way I can determine who your representatives are in the state legislature and in the U.S. Congress. And then finally, we are in the process of seeking members for our Advocacy and Public Affairs Working Group, which used to be our Advocacy and Public Affairs Committee, which helps out with our efforts in that regard. So if you're interested in being considered for that working group, please send me an email and we can further have a discussion on that. So I think it's about my 10-minute allotment of time, I think. If we do have time down the road, there are a bunch of executive orders and bills that were signed into law by Governor Murphy that don't directly pertain to brain injury, but could benefit the brain injury population. But for the sake of time, I want to make sure I got those initial pieces out. And again, any questions, please do ask me. Thanks. Now I'll turn it over to Gwen for the presentation.
Thanks, Tom. I'm going to wait now where we're going to get the PowerPoint up that Michael Brower is doing. Michael, I'm just asking, it's not filling my full screen. Is that the full share mode of the presentation?
Yes.
Okay, that's great. So, well, thank you, everybody. On behalf of Disability Rights New Jersey, we're thrilled to be here presenting today under these really unusual circumstances. I will say at the outset that our intent in this presentation, when we put this idea together, this proposal together, was to have a session that was very interactive, that gave you substantive content about advocacy support around home and community-based services and supports and employment, but also did that in the context of working through case studies where we could really work together and share information. And obviously we're now in this altered this altered setting for presenting this. So, bear with us. It'll be a little bit more of a challenge than if we were all together in the same room. The other thing I would say, I'm not sure if this was mentioned yet, but we, before I get us started, we are going to take questions, both about the presentation by Michael on appealing and advocating for services and supports, and the presentation for Mary on employment advocacy. And you can put those questions in the chat box. There's both a Q&A box and a chat box. I'll be monitoring it to get those questions to our panelists. So we'd ask that you put them in the chat box. It's just easier if they're in one place. And then Susan will be doing our case studies at the end, and we'll take questions and feedback then as well through the chat box. And we are going to save all questions for the end. So next slide, please, Michael. So I just wanted to let you all know about our new COVID-specific website. So in this strange time, Disability Rights New Jersey was just on the cusp of doing a rebrand this spring that involved doing over our drnj.org website, which I think is from the year one. So we were really looking forward to that. And then we found ourselves living in this COVID pandemic world. And so our focus switched from what we had planned for the spring to really intensely working on issues related to advocacy for individuals with disabilities around COVID. And what we found was our old website just couldn't accommodate all the information, all the advocacy, all the webinars we were doing to provide information and services and advocacy to folks during this time. And so we launched this new COVID-specific website, and I would really encourage people to go there to find out more information. So next slide, please, Michael. Here is what we're going to be talking about today. Michael's going to be reviewing appealing denials and reductions in therapy services related to traumatic brain injury, as I said, in home and community-based settings. Mary is going to talk about self-advocacy strategies in the context of employment, and then Susan's going to lead us in our case studies. With that, Michael, I'll turn it over to you. And now I believe I am shifting this. I apologize to the audience. This is a change from what we had planned. I am forwarding the slide. So Michael, I'll just need a cue from you.
All right, thanks. Go to the next slide, please. Excellent. Hey, good afternoon, everyone. This is Michael Brower. I've been introduced, so I'm not going to reintroduce myself. I just wanted to give a little bit of a roadmap. I'll be taking care of the first segment when we talk about appealing denials and reductions of TBI-specific services, and a lot of these things are going to apply to other Medicaid services as well, through a managed care organization. So what we're going to cover is how to request an appeal and how to preserve your rights when a managed care organization denies, reduces, or terminates services, including TBI services that are delivered through Medicaid. We're going to review the rights of the beneficiary during the appeal process and walk through that process step by step so that you'll be empowered to advocate either for yourself if you're a person who receives services, or for a client if you work with somebody else who receives services. Most importantly, we're going to be highlighting actions you must take to keep services that were already being delivered during an appeal or termination, or if there's a reduction of an ongoing service. Next slide, please. All right, let's start by laying some groundwork with a few definitions. I'll try my best not to use any abbreviations if I can help it, but I'll slip now and then, so let's go through a few. First, we're going to talk about MCOs. New Jersey operates its Medicaid program in partnership with the federal government. It provides medical coverage and services for New Jersey's most needy citizens. Individuals on Medicaid are enrolled in one of the 5 managed care organizations, commonly referred to as MCOs, and the list is up on your screen of the 5 that operate in the state. The MCOs contract with the state to maintain a network of providers, such as doctors, hospitals, pharmacies, community service providers, and the managed care organizations make payment for Medicaid services. And finally, they also authorize those services. They're the front-facing organization that administers Medicaid services in New Jersey. When a managed care organization denies, reduces, or terminates a service, that's called an adverse benefit determination. That's the second term on the screen, the ABD. We'll give you some examples of what an adverse benefit determination could be in a second. And finally on the slide, continuation of benefits. It's extremely important. Probably going to be sick and tired of me saying continuation of benefits, but for people who are receiving ongoing services and are facing some kind of termination or reduction, it's often one of the most important things that they need to be aware of to make sure that they don't go without services while they're trying to appeal what they see as an inappropriate reduction or termination. If you're already receiving a service and a managed care organization wants to reduce or terminate it, you can continue receiving the service during an appeal, but you must take the right actions and you must take them at the right time. Next slide, please. I promised you some examples of what an adverse benefit determination might look like from the last slide. Whenever an MCO makes an adverse benefit determination, they must provide a written notice. So here are some examples of when a managed care organization will be required to provide a written notice that they've taken an adverse benefit determination. If somebody's been receiving 35 hours a week of personal care assistance, but the managed care organization nurse has performed a reassessment and decides that only 15 hours per week is medically necessary and therefore reduces the authorization to only 15 hours of personal care per week. Another example is if they terminate acute rehabilitation services because the MCO believes that the benefit is no longer accruing to the patient, or if the managed care organization denies pre-authorization for a specific surgery that's been prescribed, again, because the managed care organization believes it's not medically necessary. In each of those instances, the managed care organization would have to provide a written notice explaining the action it took, whether that was a denial of a request, whether there was a reduction of an existing service or the termination of an existing service, an explanation of why it took that action, and an instruction on how the beneficiary can appeal and what their time frame is for an appeal. Next slide, please. If there's an adverse benefit determination, like I said, you must be notified in writing. A call from a care manager or from the provider agency is not sufficient. The notice must be in writing and it must be from the managed care organization. Whenever a beneficiary receives a notice, my advice is always to keep all the pages of the notice because there's going to be a lot of material contained, like the explanation of why, the timing, and also save the envelope that it came in. We're going to talk a little bit more about the timing and why that envelope might be important in just a second. So a little bit of a preview there. One of the things that's important to think about, and the first timing thing we're going to talk about, is the managed care organization is supposed to mail the notice at least 10 days before the date of the proposed action. Keeping the envelope is one way that you can help figure out if the managed care organization sent the notice on time. Next slide, please. Thank you. So during the appeal process, there's a couple of basic rights that the beneficiary has that apply generally. Reasonable accommodations in the appeal process. This might be an interpreter, and it could be American Sign Language, could also be foreign languages, or assistance in a reasonable accommodation in filing the appeal. That is an accommodation for somebody's disability. The ADA still applies in the managed care world. The beneficiary has the right to the confirmation that the managed care organization received an appeal, a written confirmation that things were received, a free copy of the entire case file from the managed care organization if it was requested. I generally will tell people there's no harm in requesting it, and it's a good practice to always request it and make that request in writing. That way, you have a record of when you made a request, and you can see the managed care organization's file and helps you get into their mind why they made a particular decision, and if you're appealing it, what might be a good strategy to appeal. The beneficiary has the right to submit new evidence that wasn't available at the time they made an initial request or at the time the initial decision was made. So that could be doctor's letters of medical necessity, new test results, other medical records that might be helpful in changing a managed care organization's mind, even if they didn't exist or weren't considered when the managed care organization took its initial action. The beneficiary has the right to present evidence and arguments in person. And they also have the right to have assistance from a friend, a family member, an advocate, or an attorney. There's not necessarily a right to an attorney in the sense of a criminal trial where everybody's appointed a public defender even if they can't afford one. in the Medicaid world, there are several organizations, Disability Rights New Jersey included, that provide free legal assistance. But if an individual doesn't have access to an attorney, they can represent themselves, they can be represented by a friend or family member, or otherwise. Next slide, please. So we've laid out some of the groundwork. I want to take a look at an actual notice. Most notices are going to look just like what's up on your screen here, but instead of black boxes, which I put on this to redact out any personally identifying information, you would see the beneficiary's name and address and their managed care organization's logo up at the top. The first and the most important thing that I look at whenever I see an adverse benefit determination notice is right at the top. That's going to be the date of the notice. It's the same place you would expect to see a date on any other letter, right at the top. The other thing I look for is you'll see in the first page, there's a series of check boxes with one of them checked. That's the description of the action the managed care organization is taking and the date that it will go into effect. On this notice, the date is May 9th. That's when it was sent. And the action is a denial of a request for new private duty nursing services at home with an effective date of May 2nd. So here's examples from somebody who requested private duty nursing for the first time on May the 2nd. The managed care organization immediately denied that request and sent a notice on May 9th. Had this been an ongoing service that was being reduced or terminated, those dates would probably be flipped. We'd be talking about a managed care organization sending out the notice prior to the effective date of the notice. Next slide, please. The date of the notice and the date that the action goes into effect are extremely important for continuation of benefits whenever we're talking about a person who has an ongoing benefit. This could be anything from personal care assistance, private duty nursing, they're some of the most common, physical therapy, or any of the TBI specific services that are available through New Jersey's Managed Long-Term Services and Support, also known as MLTSS, Medicaid Waiver Program. You can keep an ongoing benefit while you go through that appeal process, but you must make your request for the first appeal within either 10 days from the date on the notice of adverse benefit determination, or before the effective date of the proposed reduction or termination, whichever comes later. If you don't know when your current authorization runs up or when the date would be effective, you can either look at the first page of the notice letter or get in touch with the provider to see when their current authorization expires. Continuation of benefits is not automatic during the appeal process. If you miss the boat, the services can be terminated. Say an individual was getting 10 hours of TBI behavioral management support per week through Medicaid, but the MCO wants to reduce it to 2 hours per week of 2 hours per week based on a new assessment that's been performed. If the individual disagrees, but doesn't submit their first appeal within that window, either 10 days from the date of the notice or before the reduction goes into effect, if they miss that boat, their behavioral management services will be reduced and they'll be forced to go through the appeal process with reduced supports in the community. That might make it impossible or extremely difficult for them to continue through the appeal process. If you do make your request on time, that is within 10 days of the notice or before the reduction takes effect, you will not lose your services until a final decision is made. Again, if you miss those deadlines, you might still be able to appeal, but you may not get a continuation of benefits during that appeal. Next slide, please. All right, so Gwen, I'm going to walk you through this with a couple of clicks. Up on the screen, we have a calendar. For somebody with an ongoing service who receives a reduction or termination notice, we know now the rule is that you must file within 10 days or before the effective date of the reduction or termination. But how do you actually count those days? Got a calendar of May up on our screen, and May 1st with the green circle, let's say that's the date of the adverse benefit determination notice, May 1st. If we click the mouse 10 times, I'm sorry, I would have been doing this myself before we had our technical problems. We're going to add some X's. We start with the day after the date on the notice, so that's May the 2nd, and we count 10 days, Wednesday, Thursday, Friday, Saturday, Sunday, Monday, Tuesday, Wednesday, Thursday, and Friday the 11th would be the 10th day. That means for somebody who got a notice dated May 1, they start counting the day after, they count up 10 days, they would have to get their appeal in before the end of the day on Friday the 11th if they wanted continuation of benefits. You'll see this is a very short deadline, especially considering that the date of the notice is also the date that the managed care organization puts it in the mail. It's going to spend several of these 10 days in the mail, meaning you'll probably have less than 10 days to look at the notice, figure out what to do, whether you want to appeal or not, and get the appeal in. If this person were to go any later than May the 11th, they might stop receiving their ongoing service. Again, there's a presumption that the managed care organization mails the notice on the same day that it's dated. We don't always see that happen. We'll get to some kind of common problems and fixes at the end of the process. But for now, let's talk about what you actually have to do before the end of the day on the 11th in my scenario here. Next slide, please. The first thing you have to do is an internal appeal. And remember, what we're talking about here is asking an MCO to review its decision to terminate or reduce a service that you are already receiving, or to review its denial of a new service that you're requesting for the first time. This is asking the MCO to take a second look at its own decision. That's what an internal appeal is. Next slide, please. It bears repeating, and again, I told you you'd be tired of me saying this, but you must request the first appeal within 10 days of the date of the notice or before the reduction goes into effect if you want the services to continue. You can always make your initial appeal request for the internal appeal by telephone, but it should be followed up by a written appeal in writing. The written follow-up should include any evidence you want the managed care organization to review, including anything like new prescriptions, letters of medical necessity, or medical records, which might indicate why the managed care organization made the wrong decision. Next slide, please. Once the managed care organization receives your internal appeal, again, which they should confirm in writing once it's been received, they'll start reviewing your appeal. They have 30 days from the date you make your internal appeal to make a written decision. It's called a notice of resolution. Once the notice of resolution goes out, a new clock is going to start ticking. It's another 10-day clock to request a fair hearing. If you don't like the outcome at the internal appeal, the Medicaid fair hearing is the next step. Worth bearing in mind here that because you're asking a managed care organization to look at its own decision and think about whether it got it right or not, you shouldn't be shocked if the MCO decides, hey, we got it right the first time around. Remember, this is the managed care organization taking a second look at its own decision here at the internal appeal. Next slide, please. If you meet the 10-day deadline for the internal appeal or for the fair hearing request that we're about to talk about in a second, you could take your time with this process. If you have an ongoing benefit, they'll have that benefit continued while you're going through and waiting for the managed care organization to use its 30 days to decide how it wants to resolve your internal appeal. If you miss that deadline, however, or if you're asking for a service for the first time, and not having that service is putting your health in jeopardy, you could ask your managed care organization to expedite the appeal. If you meet the criteria, which are up on the screen, an expedited appeal shortens that time frame down from 30 days to 72 hours. This is a fantastic amount of acceleration to help you get through this process faster so that you're not waiting without a service that's putting your life, physical, or mental health in jeopardy. Next slide, please. Up on the screen is a notice of resolution. Again, they almost all look pretty much the same, minus those black boxes, which I used. Very similar to the initial notice in format. Again, the most important thing is to take a look at the date right at the top of the letter. It's important because if you decide you need to request a fair hearing and continuation of benefits, there's a new clock that starts ticking from the date of this notice of resolution. The body of the notice down below explains what the MCO did with your internal appeal, whether they changed their mind or whether they're keeping their original decision. The next slide, please. I really can't say this enough. If you have an ongoing service, like physical therapy, personal care assistance, any kind of behavioral supports that you've been receiving, you can keep those during the process of this appeal, but only if you meet all the deadlines. The first deadline we talked about was for the initial notice and requesting your internal appeal. The second clock, which is another 10-day clock, counted exactly the same way, starts ticking for the fair hearing. That means if you requested your internal appeal within 10 days of the date of the initial notice, and then you request a fair hearing within 10 days of the date of the notice of resolution, you can continue to receive any continuing benefits through the conclusion of your fair hearing. If you miss either deadline, the proposed termination or reduction of existing services could go into effect before you've had a fair hearing. You might ultimately win. You might go to the fair hearing, convince the judge, convince the Medicaid agency to give you your services back. But during the appeal process, while you're waiting for that all to happen, for the judge to review the case, for a hearing to be scheduled, for the Medicaid director to make a final decision, you won't be going several months without the benefit of an ongoing service. That's why I keep emphasizing and re-emphasizing the continuation of benefits. Next slide, please. If the notice of resolution from your internal appeal indicates that the managed care organization is still going to terminate or reduce services, or if it will still not approve the services you asked for, that's when you request your fair hearing. A fair hearing is a chance to present your case to an administrative law judge who can make a recommendation to the state Medicaid director on what should happen with this dispute. The Medicaid director will issue a written final agency decision about what should happen to your services. The request documentation, how to ask for a fair hearing, is directed to the Division of Medical Assistance and Health Services within the State Department of Human Services, which administers Medicaid in New Jersey. Next slide, please. Up on the screen are the second and third pages of that notice of resolution. And you'll notice that on this is a blank form with some spots that somebody could fill information in. This is actually a fair hearing request form. It's required by law that anytime there's a resolution on an internal appeal, whether it's favorable or not, that this form be included. And all of the managed care organizations in practice do in fact include it. You cannot request a fair hearing until after you've gone through the internal appeal process. So this form arrives to you just in time if you need to go to the fair hearing process to use it. You should make a note. This form has a question on whether you want the continuation of benefits to continue through the fair hearing process. Again, it's not automatic. If you want the continuation of benefits, you check the box and submit the fair hearing request on time. And for the fair hearing, we're only talking about within 10 days the date of the notice, again, or before a reduction or termination goes into effect. We're going to think about this deadline the same way we talked about the deadline for the initial notice on the internal appeal. Next slide, please. Up on the screen, we've got all the steps so far laid out in order just to kind of see where we are so far. We've got the initial notice, followed by the internal appeal, the notice of resolution after the managed care organization has considered your internal appeal, and finally, a request for fair hearing. So now you've requested your fair hearing, and the case has been transmitted to be heard by an administrative law judge. What should you be considering or planning to do at the Medicaid fair hearing? Next slide, please. You can request your entire case file from the managed care organization prior to the hearing. We talked about this a little bit before. That's one of the most important strategies in determining why the managed care organization made the decision they did. You'll be able to look at any records they have, notes, assessments, phone calls they've made or recorded with you or with your providers. For the fair hearing, you're going to have the opportunity in person to present witnesses and documents on why you need the service, why the reduction or termination or denial was incorrect. I kind of break this down and think about it simply as a two-pronged strategy. Prong number one, explain why the MCO got it wrong. If they used an assessment that was flawed, if they caught you on a good day instead of an average day, if, for example, we're talking about behavioral services, if they looked at behavioral notes from your provider and they lacked any indication that those services were necessary, maybe it's just a matter of bad documentation by the provider. Maybe you can go back to the provider, get some more accurate notes from them, and take that to the fair hearing to present to the judge. Doctors, nurses, family, caregivers, the beneficiary themselves, if they're familiar with their own services and their need for services and can be able to express them to a fair hearing judge, would all be good witnesses to present. At a fair hearing, both sides get a chance to present evidence, and the judge generates a written recommendation, which, like I said before, goes to the Medicaid director for a final agency decision. The second prong of a strategy is the affirmative case, proving to the judge, whether it was an ongoing service or not, that you actually need this service, how it benefits you, why it's necessary, what are the bad things that happens if the service is not provided to you, either as it was before, or if you're asking for something for the first time, why you'd be harmed if you don't receive it. Any kind of documents, the closer they can be tied to the witnesses in the courtroom, the stronger the case. So we've taken that through a fair hearing. And with that, I'm going to turn it over to Mary Saccone. If we could go to the next slide, she'll be talking about self-advocacy strategies when it comes to employment. Thank you.
So Michael, this is Gwen. I'm just going to interrupt a second before Mary starts to say thank you for that presentation and to encourage people to ask questions in the chat box. And I would, on this section, which we'll get to at the end, I would ask you to use that chat box and also to be patient with me because we had to do this switch. I'm reading chats on my phone because I think if I read chats on this screen, since I'm sharing my screen, that interrupts the presentation. Is that accurate? Michael, if I try and read the chat box?
Actually, I think we just continue seeing the PowerPoint, so you're okay.
So now I'm seeing the chat box. You aren't seeing it on your screen?
Nope, just the PowerPoint.
Oh, great. Okay, then that makes it a little bit easier for me. Okay, great. So I apologize. I did want to say that. I also wanted to say one other thing, and you can ask questions about this, and we're happy to answer it. Michael just gave an excellent presentation on appealing denials and reductions of therapy services in a non-COVID world. It's different right now, and the good news is by order dated March 30th, any prior authorization for MLTSS services in outpatient services in effect on that day, including services for individuals with traumatic brain injury, the special services in the waiver, MLTSS waiver, all of those authorizations are extended by 90 days from the last date of the authorization. So nobody should be in this situation right now during this crisis. If you are, that is a situation where, or your clients are, or your family members are, that is a situation to reach out to Disability Rights New Jersey, and we can help with that situation. And with that, Mary, I turn it over to you, and just remind me, please, to advance the slides.
Okay, thank you, Gwen. Advance the slide, please. My name is Mary Saccone, and I'm going to be talking a little bit about self-advocacy strategies for employment. And the things we're going to be talking about is employment for people with disabilities, vocational rehabilitation services, employment law, and reasonable work accommodations. Next slide. Employment is a key factor of living in the community and participating in the community. Unfortunately, for people with disabilities, next slide. No, too far. There we go. That one. Thanks, Gwen. For people with disabilities, employment is hard to achieve. The numbers are really bad, and these are kind of a sampling of some of the numbers for people with disabilities. In 2019, the employment population ratio for persons with disabilities between the ages of 16 and 64, which are your working years for most people, was only 30.9%. But for non-disabled individuals, that number was 74.6%. So if individuals without disabilities were employed at a greater percentage than people with disabilities. Workers with disabilities were more likely to be employed part-time than those without a disability. Employment rate for individuals with disabilities was 7.3%, while the unemployment rate for individuals without a disability was 3.5%. So basically, individuals with disabilities were unemployed at double the rate of people without disabilities. And right now, as everybody knows, the employment situation is completely different than it was in 2019. So that number is completely changed. But basically, across all age groups, individuals with disabilities were more likely to be out of the labor force than those with no disability. Next slide, please. So in order to increase opportunities for people with disabilities to be employed, the Rehabilitation Act of 1973 requires every state to provide vocational rehabilitation services to individuals who have difficulty finding and maintaining employment due to a disability. In New Jersey, these functions are either through the Division of Vocational Rehabilitation Services, which provides services to most people with disabilities, and the Commission for the Blind and Visually Impaired, which are for people with legal blindness. Next slide. Vocational rehabilitation services can include such things to help people seek employment are services such as career counseling, supported employment, evaluations and restorations, which can be therapies, financial assessments and planning, job accommodations, equipment and vehicle modifications, training opportunities, interpretation services, and small business funding. Next slide. So how do you receive services under VR? You have to be determined eligible. And in order to be eligible, you must have a physical or mental disability that presents a substantial barrier to employment and be able to benefit from vocational rehabilitation services to achieve employment. So basically, if you are in a coma and there's no way you can work, then you cannot receive vocational rehabilitation services. But if you have a disability that you may be able to benefit through these services, which we just listed, and you can go forward and achieve an employment outcome, then you may be eligible for services. So you also need VR services to prepare for a job, get a job, keep a job, or regain a job. And individuals receiving Social Security insurance or Social Security disability insurance are considered eligible for VR services unless they are too disabled to benefit. Next slide. In order to obtain VR services, you must actually apply for them. So how do you go about applying for them? Well, one, you can contact your local VR office and complete an application. Once you complete that application, the VR office must make a determination of your eligibility within 60 days. You can be referred by other agencies. This is really common with schools. Kids who are in the transition, students who are of transition age and are going on to post-secondary employment, they many times are referred by their school to VR. But there's no referral that's required. If you want to just go on your own to a VR office and fill out an application, you can do so. Next slide. Once you've been determined eligible, then the VR agency and consumer will develop an individualized plan for employment. It's called an IPE, which is different than the IEP, which is school. The IPE is specifically for DVRS and CBVI, and it sets forth a plan for how you're going to achieve an employment outcome. So what's in an IPE? It must state the date the services are to begin and the date the vocational objective is to be achieved. It must contain a list of specific services that the agency is required to provide. That could be, are they going to provide supported employment? Are they going to provide a training? Are they going to provide a vehicle modification? What services? Are they going to provide some type of evaluation, assessment? Are they going to put down some other service, some therapy services? What services are they going to be provided? And those must go into the IPE. It must contain objective criteria, evaluation procedures, and schedules for determining progress toward the objective. And it also must contain a description of the client CAP, which is the Client Assistance Program. And CAP is located within DRNJ, and it provides advocacy services if an individual is having difficulty getting their services from the VR agency. So if you are working with VR and you're disputing what services they're to provide or what services, what objective you want or just some kind of difficulty, you can contact CAP and they can provide advocacy services to you. Next slide. So that's the services that can help you provide gain employment through the vocational rehabilitation system. However, once you go to get an actual job with an employer, you have to face potential discrimination, which for people with disabilities happens unfortunately frequently. However, there are laws that prohibit such discrimination, and you need to know your rights regarding what laws prohibit discrimination against people with disabilities in employment contexts. The first law is the Rehabilitation Act of 1973. So the same law that set up the VR agencies also prohibits discrimination by agencies that receive federal funding. So agencies that receive federal funding, and that's a very broad area. It's not just, it can be any agency that receives, so post-secondary schools that receive financial aid assistance, or hospitals that receive Medicaid. There's a lot of things that are private entities, but they still receive federal funding. Those agencies cannot discriminate against you based on the Rehabilitation Act of 1973. They also can't discriminate against you under the Americans with Disabilities Act. And that is basically any employer with 15 or more employees that is not, basically not the federal government or not a religious entity, is covered by the Americans with Disabilities Act, Title I of the Americans with Disabilities Act. And those private entities cannot discriminate against individuals with disabilities. Also, in New Jersey, the New Jersey law against discrimination is even broader and prohibits discrimination against individuals with disabilities in employment. And unlike the ADA, which requires there to be 15 employees, in New Jersey, they only require 1 employee. So it's broader in terms of, basically, if you're an employer in New Jersey, it does not, then you are subject to the New Jersey law against discrimination. The only exceptions are the federal government is not subject to New Jersey law, and the religious entities. All 3 laws prohibit discrimination in the hiring, firing, and advancement of individuals with disabilities employment. And all 3 laws require the employer to make reasonable accommodations to individuals with disabilities. Next slide. So what is a reasonable accommodation? A reasonable accommodation is any accommodation that aids employees with disabilities in performing the essential functions of their jobs, unless such a change would be an undue hardship. And these can be things, examples such as modifying a workspace, modifying a schedule, providing assistive technology, providing readers or interpreters. It can be, and it can be even broader than that. So this is one of the key things that can help people with disabilities maintain or gain employment. Next slide, please. So if you're working and you're having trouble doing a job, but you think there's an accommodation that might be able to help you, say there's some assistive technology that would help you perform the job, there's a process that you have to go through to gain that assistive technology, that accommodation. So the process is basically the employee must first make a request to the employer saying, hey, I've got this disability and it's causing me to have this problem with my job. How do I go up? And I think if I get this piece of equipment, I will be able to do the job much better. Okay, so they've made the request. They've said, hey, this is my disability. This is why I can't do this job or what I'm having trouble with. And this piece of equipment will help me do this job. Then the employer and the employee must engage in an interactive process to determine what accommodation is reasonable under the circumstances. Next slide. Once the employer is asked about a reasonable accommodation, the employer then should analyze the particular job involved and determine its purpose and essential functions, and consult with the individual with the disability to determine what job-related limitations are imposed by the disability and how those limitations can be overcome with a reasonable accommodation. So, as I say, if a person says, I need a modified workspace to do my job, okay, the employer comes in and then they look at it and they say, okay, well, why doesn't this workspace work for you? And the employee can say, well, because the desk is too low, it causes my back to, and I can't get to places, or whatever the issue is for that particular workspace. And then the employer says, oh, okay, we can buy a new desk that's a little higher with a chair that will work out for you too. Okay, great, that's an accommodation. Next slide. As I say, in consultation with the individual, you identify potential accommodations and assess the effectiveness each would have. And the goal is also to consider the preference of the individual with the disability to determine whether that accommodation is most appropriate for the employee and the employer. Next slide. The employee's responsibilities are to make the initial request for the accommodation and provide all information that the employer needs regarding the nature of the disability and the need for accommodation. And they say these are reasonable requests, so they can't go hunting through your medical records to determine whether that's necessary. And for some people, if it's an obvious disability, if you're in a wheelchair and the desk is too low, that's an obvious disability and it's obvious what the person needs. They don't need to be going and looking through your medical records to determine your need for that. If it's a hidden disability and it's not obvious what the need is, then you might have to provide a little more documentation about what the specific disability and the specific need and how they go together. But that's all that's required. They can't go looking through your whole medical records. Next slide. And then the employee is also responsible for considering all offers of accommodation. And if not appropriate, providing an explanation as to why it's not appropriate, or provide an explanation as to why one alternative is better than another. The employee is not entitled to the best accommodation. The employee is entitled to the appropriate accommodation. So the employer can say, we're not going to give you this really fancy desk. We have this one desk that meets your needs based on what you're telling us. Okay, fine, then that's fine. So if what they come back with isn't going to work, then the employee can tell them, hey, this isn't going to work and this is why. Next slide. If there's some accommodation that you say you need as an employee, you're having trouble with work and you're not sure, but you think you need an accommodation, but you don't know kind of what accommodations are out there, I recommend, and also for employers trying to decide accommodations for people with disabilities, contact the Job Accommodation Network. It is the leading source of free, expert, and confidential guidance on workplace accommodations and disability employment issues. Their website is www.askjan.org, and they provide a lot of information. They are experts on accommodations, and they can come up with ideas that people don't necessarily think of. And when it comes to, I view reasonable accommodations as a win-win for everybody. It allows the employee to continue to do their job and in a way that provides productivity, and they produce for their employer. And the employer then doesn't have to train somebody new or find somebody new. Everybody wins when the individual can actually do the job. So, and that's what reasonable accommodations do. Thank you. That should be the end of my discussion. We're moving on to the next slide. Thank you.
So this is Gwen again. Before Susan walks us through our case studies, we're going to ask, Susan's going to be asking some questions, and she's going to ask if people could participate by putting their thoughts and their suggestions in the chat box. And after we finish these two case scenarios, then we'll go back to the questions. But because of our technical difficulties, I will be looking at the chat box, which means I can't be looking at the slide. So I just ask people to be patient with that. And Susan, since I won't be able to see the slide, I'll be watching the chat box. If you could just give me verbal cues. Okay? And I turn it over to you now. Okay, I'm just checking. Susan, maybe you are having some difficulty with, let me see if I unmute you. No, I cannot unmute you. Oh, there I did. Susan, I think you should be unmuted now.
Okay, thank you. So good afternoon, everybody. My name's Susan Head. And in this section of our presentation, we're going to look at two case studies and identify some advocacy supports and strategies that we can use, thinking about the information that Michael and Mary presented earlier. So this case study involves a 29-year-old female with a TBI who receives Medicaid managed long-term services and supports. highlighting the details in the second paragraph, we can see that this individual has been and is receiving 3 hours of occupational therapy per week at a specialized brain injury rehabilitation day program. She was recently advised by the facility staff that her occupational therapy was going to be reduced to 1 hour per week. But the clinicians at the day program recommend that she continue with the 3 hours, and have informed her and her family that she's been making great progress and they'd like to see that continue. So thinking about the Medicaid appeal information Michael presented earlier and using the chat box, what advice would you give to the individual and her family about steps that they can take to try and maintain the 3 hours of occupational therapy per week she's currently receiving? So we'll pause here for a few moments to give you time to enter your advice into the chat box.
Great, thank you, Susan. I know the chat box is working because I can see some other people put some questions in. So, so we're looking for thoughts and suggestions about what steps this individual could take to maintain the services she has, or even get increased services if that's what she thought she needed. So one of our participants said that they can appeal to the MCO, pointing in within 10 days, because she heard you well, Michael, to continue the services while the appeals go on. And somebody else suggested that you begin by reaching out to the case manager or the care manager for MLTSS to get more information and find out why the services were being reduced. So with that, Susan, oh, wait, one more coming in. Oh, now they're all coming in. Appeal the adverse determination and gather statements from the therapists and the doctors to get supporting documentation. File an appeal immediately, gather information. A lot of folks clearly were really listening. And then someone said the therapist should have good data on her baseline and the progress that she's made to justify the continuation of the services. And somebody else says, as always, a good piece of advice to keep the paper trail and with respect to the appeal. And with that, Susan, I'm going to turn it back to you to go through some of the solutions. And I will switch to the next slide. Okay.
Great. Yeah, great. Thank you. Well, those were really great responses. And you can see from the slide here that most of you hit the correct plan of action. If the MCO is responsible, you know what to do. Find out if the MCO sent the individual an adverse benefit determination notice. The MCO must provide written notice at least 10 days before the date of action. And, you know, it seems that you have remembered, but continuation of benefits, always be thinking about that the minute that you hear that there is a proposed reduction or termination, because benefits can continue pending the appeal as long as they're submitted within the 10 days. We've also included the phone number of the MLTSS Office of Quality Monitoring. This office is within New Jersey's Division of Medical Assistance and Health Services. And it may be a good place to go in the case no notice was sent or continuation of benefits was requested within the allowable time frame, but the MCO went ahead and terminated or reduced the services. So you can make a note of that number and use it in those two specific examples. And
Michael, would you like to add anything?
Yeah, I just want to chime in that in this fact scenario, and it's pretty common, unfortunately, is that a lot of times people, beneficiaries that is, will find out from their provider that a service has been reduced or terminated, and they never receive that written notice. So don't be surprised and don't miss the fact that from the beneficiary's perspective, they never received that written notice. From a due process perspective, it's hard to figure out when the 10 days would even start ticking if you don't have the notice in your hand. That would be my priority number one if I were to get this case landing on my door. And with quality monitoring, I would agree, if you don't have the notice, you can't get your hands on it readily, that would be one of my first calls. That generally find the folks at that office to be very responsive, very friendly. I wouldn't go there for a substantive question on, hey, this appeal seems inappropriate, they're still benefiting, they're not going to look at the data on whether the service is necessary, but something very concrete and discrete. The services are being reduced or terminated. I never got the notice. Or I filed my appeal on time. I got everything in on time. I know it. Here's my records. But my services were still reduced or terminated. I should have gotten continuation of benefits. Help me. MLTSS Quality Monitoring Office with the phone number there on the screen. Very valuable resource for those two really specific problems.
You have 10 minutes.
Thank you. And I would just add that disability, if your services are stopped and you think that that was contrary to your rights, disability rights can help with that as well. One other thing that I would just point out, especially on the TBI specific services, sometimes MCOs are terminating or reducing those services using what I would call typical standards, for example, for physical therapy, occupational therapy, speech therapy. They're not really complying with the special rules that go along under MLTSS with the TBI specific versions of PTOT and speech therapy by way of example. So that is a good point of inquiry. I'm actually going to, because we have 10 minutes left and I want to get to the other question, I'm going to actually wrap in one other question that was asked more generally during your presentation, Michael, about how to get a copy of the file from the MCO and what do you do if they try to dissuade you? And I think that's a really excellent question, and it's one that we've struggled with because as files have become electronic, it used to be in the olden days, I've been doing this a long time, you know, you would just go someplace in person, you might even appear, and they would have you go through a paper file and you would have what you wanted and they would make copies. But it's a lot more difficult with electronic files, especially to get the documentation of the, you know, the basis of their decision, what made them change your services. So Michael, do you have anything you can say to help address that?
Yeah, and I'll try to be brief to make sure we get to the next question. But there's really two scenarios. If you're in the internal, if you're in the context of the internal appeal process, the timing is also short that I would request my appeal anyway. Even if I couldn't get my hands on the entire file because there's such a close turnaround, I would probably request my appeal even if I didn't have the benefit of the entire case file. I would still request the entire case file, but I think practically speaking, just to keep my services going, I would do what I need to do to get in on time. If you're in the context of a fair hearing, you can request your fair hearing and continuation of benefits just by submitting the form to the Division of Medical Assistance. Everything gets transmitted over to an administrative law judge. You've got a little bit more breathing room if you did all of that on time. So what I would do is I would make my request for the entire case file in writing. I would address it to the MCO, and if they had a counsel who's already appeared in the case, to their counsel. I would give them a reasonable but short amount of time. In my mind, 7 days or 10 days always feels like enough time. If they need an extension, they can always ask for it. And if the managed care organization still doesn't send the entire case file, if I'm in the context of a fair hearing, I would think it would be appropriate to reach out to the judge, probably again in writing, copying the managed care organization or their representative, and request some assistance from the administrative law judge in compelling the managed care organization to give you your file. Part of the administrative law judge's job, really the core of their job, is to develop a complete record. It's pretty difficult to develop a complete record of what's going on in the case if one side is keeping secrets from the other in violation of the rules of the game. So I wouldn't hesitate too long before contacting an administrative law judge to ask for some assistance if I had a resistant managed care organization involved in an appeal.
Thank you, Michael. I want to turn over to the other question, but there are two that showed up in question and answers that I'm going to answer very quickly. Somebody asked about recreational therapy. So I can't answer that question right now because I don't have access to my computer and my phone is too small for the 858 page long MCO contract. But if you go to the New Jersey Medicaid MCO contract, do a Google search on that. There is a service dictionary at the end of that, and you can look at all the TBI specific services under MLTSS and read a definition of all of those. And yes, to the person who asked about care managers, they're called care managers in MLTSS. Everybody has to have one, and you remain on MLTSS for as long as you're still eligible. You meet a nursing facility level of care, and in the case of individuals with traumatic brain injuries, you meet that additional standard related to traumatic brain injury, which is beyond the scope of our presentation today. And now I will turn it over to you, Susan. I apologize, there are 5 minutes left for the second question.
That's fine, we'll go fairly, yes. So in this case scenario, the key points are that the individual is unable, as a result of the TBI, to go back to her previous occupation, which was as a registered nurse. So she needs a new occupation. So she went to DVR and couldn't reach agreement with DVR about the choice of the employment goal. And as Mary highlighted, the DVR and the consumer need to develop this IPE, this individualized plan for employment, which is essentially the roadmap of DVR services. It's what DVR agrees to provide. And the employment goal is really important because it determines all the services that DVR agrees to provide so the individual can achieve their employment goal. So in this case scenario, DVR thought retail, career in retail was appropriate. The individual wanted to work in a nursing home with residents. Agreement could not be reached. So there was a little bit of an impasse there. So Gwen, I'm thinking we just move straight to the next slide and any questions can be,
Yes.
yeah.
There you go.
So basically, the suggestion would be to have the individual meet with supervisory or management staff to resolve the impasse. DVR can conduct career exploration, including work trials. So one suggestion would be to say to DVR, well, look, I understand that you don't think this is a good occupation, but possibly I could do a trial in a nursing home, and then DVR can explore the individual's vocational strengths and limitations. Also, if an individual needs assistive technology to successfully complete a work trial, DVR can commission an assistive technology evaluation to look at which technology may be helpful for the individual to try and be successful. If agreement cannot be reached, the individual can always contact our CAP program, and we will try and provide advocacy services to that individual.
Thank you. So I think we have literally 2 minutes left. MLTSS stands for Managed Long-Term Services and Supports, and it is a Medicaid waiver. You can find out about your own state on medicaid.gov and going to their waiver section. If you opt for continuation of benefits but ultimately lose, do you have to repay them? Theoretically, yes. I've been doing this for 30 years in Medicaid. Never seen it except overpayments in the case of fraud. Like you were not eligible for the program at all. You failed to disclose that you had, you know, $50,000 in a bank account. But anytime somebody in good faith is appealing, I have never seen an overpayment. And I'm going to go to the chat box. Oh, questions now are popping up all over the place.
Well, I'm sorry to hear that, but it is time for this workshop to end. our attendees need to move on to another workshop. Please complete your evaluations. Refer to your email in the workshop links to select your next workshop. And we will begin the next workshop in 10 minutes. Thank you, and thank you to our panelists. It was great having you here with us today.
Thank you so much.
Thanks, everyone.
Thank you.
Thank you.